Lovely, thank you. Just give it a couple of minutes for a few more just to jump on, and then we'll do the introductions. It looks like a well-attended seminar this morning, so that's really lovely to see. Thank you all for joining. So I'm Anya Lomax, Chair of the Alliance for Finance. I'd just like to welcome you all this morning to our second Employment Law and Employment Rights Bill update. This again is provided by our friend David Sorensen from Morrish Solicitors. There's lots to go through in this seminar and with the slides that David has provided for us today. So I will hand over to David, and questions as always, if you want to put those in the chat function, and we will go through those at the end of the actual seminar itself. So thank you very much, and I'll hand over to you, David.
Oh, thank you, Anya, and good morning, everybody. Anya's going to be operating the slides, so we could have a good comedy double act here, couldn't we? So,
we could. I'm just going to share my screen, hopefully, and the slides.
That looks good. So, shall I get started then? There's quite a lot to get through. I'll try and keep it as short as I can. The Employment Rights Bill is a big piece of work, and as you probably may well know, was back in the House of Lords yesterday, so it's very much a live and very hot potato. So I'll cover things as quickly as I can. A little bit about us at Morrish. I think hopefully many of you know about us. We've been a trade union firm for a long old time, since about 1906, and we've been going a little bit longer than that as well. And we now have the honour and pleasure of acting for nearly 40 trade unions and associations. And just a little bit on our services. Again, we cover all the things you think we should. And obviously I'm an employment lawyer for my sins and the managing partner, but we cover all other aspects of legal services for individuals and for members. We don't act for companies or insurance companies or anything like that. We act for unions and individuals, and have done for a long old time. Anyway, moving on, I will whiz into the agenda, which is an A to Z. Because I don't know about you, but when I try and get into the detail of the Employment Rights Bill, there is so much, and that's a good thing, but there's so much, it's very difficult to keep up to date with it. And I do know that when polling has been done, the idea of these changes is very popular with voters, but equally, most of them, when polled, don't have much detail about what's coming. And so what we're trying to do is do it in an A to Z order. So it may be very diverse and move through various different topics, but it kind of helps, I think, just to try and keep a level of control over the detail. And obviously it is a moving piece. So some of the slides are already out of date, but I will add a bit of detail for the changes. And it is one thing we're going to have to keep an eye on. And it very much, of course, in terms of the government, there is a challenge from the House of Lords and the government, and politically, the question is who's going to win out. Ultimately, the House of Commons should win out, but obviously it's politics. So we will talk in a second about some of the detail and some of the potential sort of flashpoints that business are pushing back against, is the way to look at it. But also, just to start, where are we currently in terms of the United Kingdom? Just very briefly, out of the 30 largest economies of the world, in the last international survey, when it came to employment rights protections, we are down at the bottom, 28th, with Canada at 29th and the USA at 30th. And that means the other 20 plus large economies are ahead of us in terms of employment protections. And that's a measurement of not just employment law, but health and safety and other aspects too. So we're a little bit down the league table, and that's before the Employment Rights Bill. And if the Employment Rights Bill comes in as intended, it will lift us up the rankings. We'll ultimately have to see where we sit. We've quite some way to go, but we will look now at some of the detail. I'll just laid out. I'm not going to go into detail the sort of month by month account of what's happened with the bill. Safe to say, to be fair to the current government, they promised to start it within 100 days, and they did. And Angela Rayner was a key part of that. But whatever anyone's politics and anyone's feeling toward Keir Starmer, he's stuck to his guns as well through this process in his public statements of supporting it. And that certainly, I was a bit worried that after Angela Rayner resigned, that the strength behind that would weaken, but it hasn't. Certainly not publicly anyway. But like I say, there's a bit of pushback. But anyway, it's going through the process, and we're now looking at the sort of the last rounds of the ping pong between the House of Commons and the House of Lords. But let's get into the details. So if you don't mind moving on to the next slide, and I'm just going to break down the topics of what we'll be looking at. So more protection against collective large-scale redundancies, more collective consultation, more discrimination protection, protection against dismissal and rehire, more families and pregnancy rights, improvements to flexible working, improvements in terms of outsourcing and collective bargaining. And if we just turn to the next slide, there's then also quite a lot of individual rights, enhancements to SSP, more trade union rights, increases in tribunal time limits, unfair dismissal, which is a particular issue with the House of Lords, working time, and 0 hours contracts. The 0 hours piece is probably one of the weakest pieces of the bill, but we'll look at that shortly. So again, taking it in alphabetical order, we start with collective redundancies. So one theme of the Employment Rights Bill is the fire and rehire and collective protection sort of piece. And the intention is really to strengthen the United Kingdom's protections. P&O has often been quoted, and the fear that a multinational company will make a decision on which country shall we choose to make redundancies, make job cuts, down to cost, which is, of course, what P&O did and others have done. So there are a number of things that are strengthening these protections. And if we just turn over to the next slide, what we are looking at is changes, hopefully, to the number of employees who are affected. Currently, it's 20 or more at one establishment to trigger collective consultation, and there are going to be some changes to that. We don't yet have all the detail, and I'm waiting to get that through. So, but currently, that's under consultation. So some of these areas are under consultation. We haven't got the detail yet, but the thrust of this is to increase the protection. And if we turn over to the next slide, twinned with that, there is also an increase to the protection of what's called a protective award. So where an employer, when there's 20 or more affected individuals with a collective redundancy, the employer that offends that legislation can be ordered to pay a protective award currently of up to 90 days pay. The intention is to increase that to 180 days. So it really doubles the size of the award, again, as a deterrent factor for these kind of situations. And if we just turn over to the next slide, we then move on to a slightly different theme, which is improving the sexual harassment protections. So as I'm sure you're aware, back in October last year, those were tightened up to ensure that employers need to take reasonable steps to prevent sexual harassment. And what the current government are proposing to do is to ensure employers have to take all reasonable steps. Now, that may only seem a small detail, but all reasonable steps is a much higher burden. And then if we turn over to the next slide, they're also looking at reintroducing protection against third-party harassment. That was discarded by David Cameron's government. It was originally the Equality Act that the previous Labour government brought in, and they're looking at bringing that protection back. The question is, of course, how you define a third party and who's going to be covered by that. But currently, there is a lack of protection for employees who are harassed by third parties, say, visiting the workplace. And the design here is to improve that protection. So we need to see more detail, but it's a move in the right direction. And if we just turn to the next slide, that just sets out some of the steps in terms of what reasonable steps an employer has to take. There's nothing unusual here. It's risk assessments and sexual harassment plans and so on in an attempt to reduce the instances of sexual harassment. And if we just move to one more slide, that there is also a proposal, quite rightly, for those who complain about sexual harassment to be treated as whistleblowers. That is currently an area of protection that needs beefing up, and so that's the intention there, which again seems a sensible step. And if we move to the next slide, we then look at employers, large employers, so 250 or more employees, and that will cover many of the employers, of course, you're involved with, to actually undertake equality action plans. So with an intention of improving gender balance, the gender pay differences and so on within the workplace. Much more detail needed on that, but we'll wait and see that detail. And then if we move on, as you can see, I'm going through quite a list here. We're only on D, so there's quite a bit to come. So forgive me, but here we get back into fire and rehire. So we talked about the collective consultation piece, and now we're looking at individual rights. So this is protections against being fired and rehired and what that means. So the intention is to make that automatically unfair. So to dismiss an employee, and this will be a day one right, an employee for refusing to agree a change in the contract of employment, or where the intention is to replace that individual. So that would be automatically unfair unless, and if we, Anya, you just turn to the next slide, there is one exception, and that's what's called the financial difficulties exception. So if we just pause where the current law is, effectively, in that scenario, currently, unless there is another automatically unfair reason for the dismissal, then an employer can fire and rehire individuals who have less than 2 years service because they're not entitled to ordinary unfair dismissal rights. So this change would bring in day one rights that protect people against being fired and rehired. And the only way an employer can do it is if they can show, and it's going to be quite a high burden the way it's drafted, that they are in financial difficulties. So they have to show that the reason for the change, the reason for the situation is basically so serious that it's likely in the immediate future to affect the employer's ability to carry on trading as a going concern, or where the employer is a public sector employer, the financial sustainability of their statutory functions is affected. And the employer could not have reasonably avoided the need to make those changes. So the intention here is to make that quite a tight exception. Currently, the exception is quite wide, so this would make it much tighter, and in fact make it much harder for the employer to be able to rely on that. Because rather than showing that they just need to make more profit, or the costs are too high, or effectively they want to increase the dividend to shareholders, they have to show that it's a really significant financial impact. That could be, I suppose, a situation and where for example, a business has a large contract that is almost overnight terminated, and therefore there's a very significant loss of work, and they have to make some drastic cuts. That could be an example, but those situations are going to be quite rare. And if we turn to the next slide, we can also see that not only that, but the employer has to follow other steps. They have to consult. They have to consult with a recognised union. They have to, if there's no union recognised, consult with the workforce. And so there are very sort of a number of steps they also need to take. So this is, as you can see, an attempt to avoid the kind of overnight P&O type fire and rehire, text message type termination, those kind of terrible situations, by placing a high bar on the employer, A, being able to show they can justify the dismissal or the change in contract, and B, they've followed reasonable steps. So it's quite a process to go through. And then if we move on, there is a code of practice intended as well. So that will be under consultation. And so we can link that to the collective consultation piece as well in terms of strengthening protective awards and so on. And then if we move on to the next slide, we're going back to individual rights. So there's a strengthening of protections for those who take family leave, and bereavement leave is also intended as well. So these are all sort of linking into it, improving that. And if we move on a little bit further forward, also introducing day one rights and changing the qualifying criteria. So the intention here is to open up leave to other employees as well, widen it out. So we then get on to a really interesting piece, which is the Fair Work Agency. So this is an intention to bring together the existing government bodies that cover the labour market, including HMRC, that has the national minimum wage kind of compliance teams spread around the country, and bring them under one house. So this is very interesting, and the UK is lagged behind in terms of many large economies that often have a single labour market kind of enforcement body. And the intention is to task it with, interestingly, payment of SSP. SSP is one of those areas that often people don't follow it up. People let it go. They don't go to an employment tribunal, for instance. And so this is a statutory body that might enforce it, or should enforce it. Also, for any failures to pay ET judgments or settlement agreements, COT3 agreements, national minimum wage and holiday pay as well. So that will be all covered by this body. And it's quite interesting because the intention, it seems, to give them quite strong powers, enforcement powers to enter premises, inspect documents, and also issue kind of like a parking ticket type fine. So an enforcement notice on the employer. If they pay it within 28 days, they pay less, then it goes up, and so on. And also, of course, the power to take legal proceedings. So this is a really interesting sort of potential development, and one that actually could greatly increase the payment of SSP, the payment of national minimum wage, holiday pay, and so on. Because often many individuals, even with the union support, may not want to take that forward. They have to identify themselves. They have to potentially bring an individual claim. So having a statutory body that will step in, like the national minimum wage is currently enforced by the HMRC, then that sort of takes away some of the time, some of the stress factor, and so on. And also, it might be a good deterrent as well. So rather than individuals having to bring their own claim, it may be brought by the statutory body, which could be really interesting. So we'll see. Obviously, ultimately, it's going to depend on the budget of the body and staffing and all those other factors as well. But it's a potentially interesting development. Right, we're only at F, so some way to go. Flexible working, intention really is to effectively make it slightly more difficult for employers to deny flexible working. So the kind of shopping list of factors an employer can currently rely on potentially goes, and a test of reasonableness may come in. So that should open up the scope of flexible working. And if we move on to the next one, we then get to the public sector. So very interesting here, where the intention is for outsourcing to be kind of more controlled to prevent two-tier workforce. And also, if we move on to, sorry, it's all on this side actually. Move on to the next slide, collective bargaining. So the expansion of collective bargaining, and particularly starting off with school support staff and the adult social care. Now, this, to my mind, the expansion of collective bargaining is a good move. When one of my first jobs, I was covered by collective bargaining, and that ensured often that the different companies actually were paying a similar level of pay, which kind of went against kind of undercutting the competition in some ways. But of course, as we know, through the 80s and 90s, collective bargaining is reduced, but the intention is to bring it back. My frustration here is not much has really happened yet, and of course it's a huge amount of work to do that. So very slow progress by the government, unfortunately, here. But again, the intention is a good one, but there's been limited sort of active progress made, in my opinion, on this area. If we move on to SSP, so this is the removal of the waiting period, changing the lower earnings limit, and that will increase the amount of SSP being paid, or will expand it to individuals and mean it's paid in the first few days of sickness. So this is part of the individual area of changes that are designed, planned to improve pay, improve incomes, particularly those on low earnings. So that's one of the individual rights. So there's quite a few individual rights like SSP that are, the intention is to improve lower incomes, but also, as part of the government's growth strategy, it's seen as a piece of that economic platform to put more money in people's pockets, so they spend it effectively. So this is all part of that piece as well. So from an economics point of view, we then get into trade unions, and there's quite a lot here to talk about. The intention is, and this is an area where, frankly, we could say, well, the government haven't gone far enough. From a union perspective, they could go further, for example, when we look in industrial action laws, which we'll look at in a moment. However, there are some very good things coming through, so which I'll go through individually, involving a statement of union rights and the right to join a union, potential union access to the workplace, trade union recognition improvements, more clarification about time off and facilities, strengthening protections about blacklisting, and of course going on strike and taking industrial action as well. So there's quite a bit here covering unions as entities, but also members and representatives. So if we go to the next slide, we can start to break that down. So the first thing is industrial action, removing minimum service levels. This was whichever previous Conservative government it was, I think it was Johnson's government, wasn't it, bringing that in to try and hinder public sector strikes, particularly those involving areas like education, fire and rescue. So those are going to go. And if we move to the next slide, we then move on to the statement of rights. So individual statement, chances are this will probably be a paragraph or a clause in someone's written particulars of employment, but it will state you have the right to join a union. Hopefully it will say, we recognise this union, you have the right to join it. And the second area is blacklisting. Now, I think we're all aware of how evil effectively blacklisting has been in terms of limiting people and where they can work. So union activists, those who have pursued a tribunal claim and so on. We know probably about the historic problems in the construction industry and other areas as well, but this is very much focusing on the AI element of blacklisting, because there's a consciousness that AI is involved in also manipulating and operating in that way. So the intention here is that will be beefed up. We haven't got the detail yet, but it'd be interesting to see what comes through, and at least it's recognised that blacklisting is still a major problem. We then move on to what's been well, I wouldn't say jokingly, but it was the Daily Mail referred to it as the trade union right to roam, and kind of fear factor about trade union reps just walking into the workplace. Well, of course, that's not the case. In fact, we haven't got all the detail of this yet, but what's developing is quite a complex request and access process that seems to be very, very paper-based, as it were, so quite document heavy. So we'll wait and see more detail on this yet. It's a little bit frustrating to me because it seems to be quite a complex process. What sounds great on the surface actually is really quite a complex bureaucratic process, but we'll see. And also it's one that would be enforced by the Central Arbitration Committee, but they have very limited resources. So we'll see again what comes of this, but hopefully there'll be more strength to it than I'm giving it credit for. If we then move on to the next, we've made it to T, so we're doing pretty well, but we get on to trade union recognition. So the intention here is to improve the prospects of recognition and changing the percentages to make it easier for trade unions to be recognised. Again, we're waiting for more detail here. There'll be a code of practice and so on. But again, it seems to be a move in the right direction, because trade union recognition is not a straightforward process, and is not an easy process for a union, as we all know. So hopefully that will simplify it and make it a little bit more easier. We then move on to the next one, which is just enforcement, just touches on the CAC and it having enhanced powers, and we'll see how that develops. And then we move on to the next, which is facilities. So the intention here is to make it more clear about what facilities recognised unions have in the workplace in terms of physical things, but also access to email, access to employees' details, and so forth. So we are waiting for more on that. But at the current time, there's probably a lack of clarity as to those rights. So this will improve that for sure. And then we move on back to industrial action. So this is an area where the House of Lords, as of yesterday afternoon, are pushing back on. So there are certain areas where that they are pushing back. One's unfair dismissal rights, which we'll talk about in a minute, and 0 hours contracts. The other is industrial action. The House of Lords are insisting on there having to be a 50% turnout for the ballot to be effective, and keeping the current sort of situation on that. So we'll see how that goes, and we'll talk about that a bit more towards the end in terms of developments. But they're also looking at, as part of the industrial action, reducing the period of notice, so from 14 days notice of action to 10 days, and increasing the lifetime of effectiveness once a ballot's positively in favour of action. Instead of having a 6-month period of effectiveness, it goes to 12 months. So it makes it a bit more practical, a bit more realistic. And here, he said, pausing for breath, we're talking about detriment and protections. Currently, very sadly, the UK is effectively in breach of international obligations in that the protections against individuals who take industrial action are not as strong as they need to be. And actually, those who take action who are treated poorly by the employer, but not dismissed, are in a weaker position to those who are dismissed. So the government has recognised this and is pushing forward with increasing the protections, making clear the protections against detriments of being treated poorly in any way because of taking industrial action and dismissal are strengthened, and also removing that there's currently a 12-week protected period, which is very artificial, and removing that, so extending the protection. So there's no sort of 6 months down the line payback by the employer on those who took industrial action, but trying to say it's covert and by other means. So that can only be a good thing, because those protections do make what is already a very often very difficult taking industrial action. When the individual knows one isn't as protected as one should be, you even feel even more in a weak place. So so those protections linked to the blacklisting protections should make some real positive change. Then, if we look just on to the future, and this is a really potentially good one, which is e-balloting. So we all know the cost of internal union elections, where they have to be postal. And of course, a stamp these days is the best part of £2, as we know, frightening amount of money. And of course, e-balloting would be a lot cheaper. And so that's under consultation too. And looking at also other CAC powers that might be extended, so that instead of a claim maybe going to the employment tribunal, it would be via the CAC. So again, more detail needed. As you can see, again, sorry if I come across a little bit hazy on some of this, but the way employment or most legislation goes these days is there's a kind of incorporating act of Parliament, but a lot of the detail is then in separate regulations. We've seen the act, which is brief, sorry, I should say the bill, because it's not become the act yet, but the kind of supportive regulations, we've only seen some of the detail, and a number of things are under consultation. So I'm giving you the sort of broad thrust of where we're going with some of the detail, but on other aspects, it's a bit light, I'm afraid, but that's just the nature of the beast. So now we've covered a lot of ground. We've covered trade unions, we've covered discrimination, we've covered collective rights. We're now getting on to ET time limits. Now, I've spent, I think, my career as an employment lawyer having to deal mainly with 3-month ET time limits. I had a full head of hair when I started as an employment lawyer, and I'm blaming that having disappeared because of 3-month ET time limits. So the current situation is most claims have a 3-month time limit, and of course, ACAS early conciliation can extend that, but the plan is to extend the basic time limit to 6 months. So that would, to me, that would be a dream. It gives us more time to play with. The intention is really it allows employment disputes to try to hopefully be resolved inside the 6-month time limit, because often with a 3-month time limit, that isn't long enough to resolve an issue, and therefore sometimes protective legal proceedings have to be issued. With 6 months, the belief is there'll be more time and hopefully less claims from the government's point of view. But either way, a 6-month time limit seems much fairer to me. And we get on to unfair dismissal. Now, this is another big one. So we're looking here at normal unfair dismissal. Right at earlier, back at the R's, we talked about, sorry, the F's, we talked about fire and rehire. That was automatically unfair dismissal in those situations. Here we're looking at ordinary unfair dismissal. And the big push from Angela Rayner was for all individuals to gain unfair dismissal rights from day one. Currently, for ordinary unfair dismissal, it's 2 years. And as I'm sure many of you know, over the last 2 decades, when a Labour government get into power, the period reduces, maybe to 6 months or maybe to a year. A Conservative government get in power, it extends again to 2 years. So currently, the House of Lords, as of yesterday afternoon, are insisting on it being a 6-month qualifying period. And the government, up to yesterday, was saying it's a day one qualifying right. However, that's not actually completely correct, because the day one right is a right that is gained on day one, but the intention is to be within a probationary period for 6 or maybe 7, 8 or 9 months, when there is still a reduced, a light version, a light touch dismissal procedure. So the day one right, the government saying there's a day one right, which is correct. However, that right is not the full right. It's not the full fat right. It's a light right, which is to still allow a light touch dismissal process. And it appears the House of Lords are pushing for a 6-month period. So we're coming at it from different angles. But the reality is, if the government push ahead and force it through, then there will still most probably be a 6-month, 7 or 8 or 9, we don't have the exact figure yet, probationary period, where it still will be relatively straightforward, we think, for an employer to dismiss new starters. So it's worth bearing that in mind. So that's the situation. And so effectively it could mean that there's a sort of light touch qualifying period when somebody can still be dismissed in a fairly straightforward way. And thereafter, once they've gone through probation, they're then on the sort of the full protection. But again, we haven't got the detail yet. So we shall see. But that was certainly one of the major things the House of Lords pushed back on yesterday. They want to they're insisting on a 6-month qualifying period. Well, we've got to the W's. We've saved the best till last. Working time and working time records. Well, this is just a straightforward one. It's a requirement for the employer to keep adequate records for 6 years. So just to ensure that those records are there so it can be tracked, so it's easier to tell whether people have been paid their annual leave, their statutory rights properly. And then we end on, I'm afraid, a little bit of a low, in my opinion, which is 0 hours, because 0 hours contracts often place the individual in a relatively weak position, because of course 0 hours by its nature, there is a lack of awareness of what work will be provided, what hours are going to be given, will you be working on a Saturday, a Sunday, Monday, Tuesday, and of course it creates a huge amount of uncertainty, causes difficulties with those individuals getting a rental agreement for a property, a mortgage, planning ahead, etc., childcare, all those factors because of the uncertainty of it. So the government have put forward a proposal that doesn't stop 0 hours, but it tries to bring in a system of guaranteed hours. So where the employer needs to provide notice of hours, there is then guaranteed hours based over a 12-week reference period, giving reasonable notice of shifts and the right and notice of cancellation of shifts as well. Where we haven't got the regulations or the drafts on this yet, but the intention is not to do away with 0 hours, but to try and regulate them. Now, I have tried to read through the drafts that have been provided, and they are really complicated. So the fear here is, like many things, is when you make it complicated, people just give up and don't rely on them, because it becomes, if we're not careful, can become a paper right. You've got it, but actually it's so detailed, it's difficult to work. And of course, many of these big organizations, many of the organizations that have 0 hours contracts are really big, and they will have an app-based model or some kind of sophisticated model to book people in to try and get around whatever system is set. So this again is an area the House of Lords have pushed back on. So they want as I understand it, they're pushing for individuals to have an opt-out of this process, which, if that's correct, is quite terrifying, because it means the employer might put pressure on the individual. Well, you sign this opt-out and we don't have to worry about it. Secondly, also, they want to bring in exceptions for seasonal workers, which I can understand. But again, it depends on how you define seasonal workers and how that works. If it's seasonal, as in fruit picking, then yes, it may be obviously it's for the season. But again, how far does that go? Does it start covering people who are holiday reps and all kinds of other things as well? So this really is getting into quite detailed territory. So it's one we need to keep an eye on. 0 hours contracts, in my opinion, needs regulating, and I'm not sure this is the answer. That's the issue. And of course, by the time it's ping pong back between the House of Commons and House of Lords, it may be amended quite significantly. So we need to keep an eye on it. But it might be, I'm afraid, in the category of lost opportunity, this one. However, they are bringing as well automatically unfair dismissal rights for those who fall within it and try and rely on the protections. So there is some protection there. But I think it's an area that just needs to be kept an eye on. The government had, you may recall, way back, they were talking about also looking at clarifying worker status. So where we've got the situation, of course, where there's a worker or there's an employee or there's a genuinely self-employed contractor, trying to combine the employee and worker into one category. But that's pretty much gone by the wayside, really, simply because it's a huge piece to do. And I think it's always proved very contentious. So that's an area as well in terms of who's protected in the first place. So that sort of links into the 0 hours piece, and is an area where I think there needs to be much more protection. But we shall see. So, Annie, if you don't mind just moving on, I've waffled on quite a lot about 0 hours contracts. I'm then going to get into the time frame. Well, this was all based on the situation up to yesterday. So now the smart money is on the time frame, probably extending a bit further because of the ping pong effect between the House of Lords and House of Commons. The key areas of dispute are currently unfair dismissal for ordinary unfair dismissal rights. Is it a one-day right, well, with a probation period, or is it 6-month qualifying period in the traditional way? The 0 hours contracts, opt-outs for guaranteed hours of work, opt-outs for seasonal workers, how that looks. There's then the question about industrial action, and the House of Lords wanting the 50% ballot requirement to remain in place, and the House of Commons not. And then there's also some arguments over the political funds for trade unions in terms of whether members automatically opt in or whether not. And you can imagine which side the House of Commons and the House of Lords is taking. So this timescale then may well extend, but it tries to set out as best we can the sort of order of changes in terms of rights. So we've got things that consultations have commenced. So as part of this process, with all the various areas of law coming in, there's got to be various consultations by statute. So those are taking place, and many of those are still open and can be fed back into, and more will be coming. So this is the opportunity for unions and others to comment on those things. So if we just move through the slides, we can see changes really planned some later this year, others mainly are going to be rolled over to next year when we've got the consultation. And then if we move to the next slide, Anya, you've got a little bit of the sort of the overall timescales. Now, really a lot of the protections won't be coming through until well into next year and the year after. Now, the government took the line that this gives the chance for business to be informed and train and be updated. I think, again, who am I to say, but I think it politically probably a misjudgment, because it also has given business the time to get organised, and not all business, but certainly there's a lot of business kickback on a number of these changes now. And every day you can hear the media reporting different organisations commenting on fair dismissal rights particularly, and the impact and so on. So there's quite a lot of arguing going on, and obviously we've, like I say, we've got the ping pong between the two, but there's quite a lot of changes. I should say, from an optimistic point of view, I think a lot of these things, from my view, should survive and come through. And if they do, I think when you look back over the history of employment law, and the majority of employment laws came in from the 1960s onwards, effectively. The 1960s was an era with the Race Relations Act and some very important pieces of legislation, and then the Equal Pay Act, Sex Discrimination Act into the 1970s. Obviously, we had a period under Margaret Thatcher and John Major where there wasn't much, although to be fair to John Major, the Disability Discrimination Act came in 95, but then it was the previous Labour government and they brought a lot in. However, when you look at that context and you look at the weight of stuff we're dealing with here with the ERB, the Employment Rights Bill, I think this is the biggest single ever change of employment law coming through. There is such a broad spectrum of changes here, most of which are very positive, and they are focusing particularly on those on low income and on unions, and of course on what they refer to as part of the growth strategy in terms of putting money in people's pockets. So moving across that piece, but looking at improving protections. So that it's quite a lot coming through. But just here on strengthening the ERB, areas that could have done better. Really, things that really are not as strong as they need to be. The right to request for trade unions, we need more detail, but again, I'm a bit worried that's going to be a little bit overcomplicated. The statutory recognition, again, more detail needed. Collective bargaining, it's a slow process. That it's the rate of movement. It's going to take decades, and have they got decades? We then move into other areas of protections. Certainly from the union's point of view, the strike action, the industrial action aspect has only been taken back to effectively 2015-16. So it hasn't gone further in terms of the other limitations that previous governments brought in. The self-employed kind of worker status point and 0 hours contracts, I've already made that point. And then lastly, another thing that sort of disappeared into the ether, as far as I can see, is the right to disconnect. That was quite a big topic about a year ago in terms of the right to switch off. Some countries have already adopted that, but that seems to have become disconnected in itself and slowly disappeared. But for all we know, it might be announced tomorrow. But again, it's one of those that seems to have slipped away. So in summary, there's a lot to play for. Obviously, we've got the ping pong, like I said, between the House of Lords and House of Commons and where that goes. We will see the strength of the government's position in terms of pushing it through and how much comes through. So it really is a good example of the political process in play and on what comes out. But hopefully a lot of what we've discussed will. Only some items are being kicked back by the House of Lords, so a lot of it is in train, as it were. But it's going to take some time, of course, through 26 and into 27. But there is a lot of good stuff there, so there are reasons to be positive about it. And the majority of the changes, in my opinion, will make a positive impact in the workplace. So yeah, reasons to be cheerful, I think. But don't quote me that in 3 months' time. But no, I think it hopefully all will be. I think then that probably, over the course of 45 minutes, has covered everything. But if I've missed anything, feel free to ask, and I'm happy to answer any questions at all.
Thanks, David. Fiona, have we got any questions in?
Yeah, we've got a couple. Thanks very much for that, David. Great update as always. This one's in from Mike Calvert. I understood that P&O's actions were illegal in 2022 anyway, and they broadly got away with it, didn't they?
Yes, are you happy for me to answer that, Fiona?
Yeah, please.
They were, and I think it was the chief executive who was interviewed, wasn't he? And he said, "Yep, we know what we've done isn't right, but we've taken a commercial decision, and we can afford it effectively." And so they had to pay a price, but the price wasn't that high, or certainly not high enough to stop them from potentially doing it again. So I think the difference here is the financial impact ultimately. If that's what's going to, that's their focus, the deterrent factor. If these changes come in with, doubling of a protective award, so if an individual, if the employer, let's say that they didn't collectively inform and consult, well, if an individual gets 180 days pay is a significant amount. And of course, then if we look at automatically unfair dismissal for fire and rehire, again, that could be significant amounts. So the deterrent factor hopefully will be the key difference here, and the cost ultimately if they do go ahead, and it stops them. I mean, for instance, I think the in certain boardrooms, decision will be taken: shall we make redundancies in Southampton, or should we make them in Rotterdam? Well, Rotterdam's going to be double the cost, so let's choose Southampton, for instance, and so on. So Netherlands is one of the countries that has one of the highest levels of employment law protection. So, but it's, hopefully these things come through and the compensation levels come through, and it will deter those kind of situations from happening in the first place. Reduce employment tribunal claims, which would be good overall, because the tribunal service is struggling, but also just be a deterrent and keep and secure jobs. Maybe I'm being naive, but I think it hopefully will have a factor, because ultimately they'll do the maths and work out what it's going to cost them to do it again.
Great, thanks very much. And on that, tribunals, questioning from Jerry Maloney. Yesterday, one of my members was told that his tribunal case would be heard in September 2027 because his former employer wants 9 days for the case. This virtually denies him the right to have his case heard, as he cannot wait for almost 2 years. Many people get worn down by such delays and give up. Has the Employment Rights Bill made any provision for such excess waiting times?
Well, no, it's a very good question again. Thanks, Jerry. Yes, I mean, it is. I don't want to, harbour back too much, but if I run an unfair dismissal claim in, say, 2003, we'd have had it wrapped up with a judgment inside 6 months. And now, it could well be 18, 24 months. So it has had that impact. And certain tribunals are now listing cases, lengthy cases, but for 2028. 2027 isn't unusual. It is really troubling. And I know there are more judges being recruited, and there's more resources going into the tribunal system. They're improving their online systems and the issuing systems, but there's still it's still really difficult for them. And I know ACAS, they are hoping to be able to employ more people, but I think the government are trying to use AI within ACAS more to try and make up the differences. So things are happening, but it's not, the system is not what it should be. But I'm afraid is the same with the court system as well in across the country. I mean, it's, the years of austerity have really bitten, and so things are difficult and tighter. But they are, I think things are slowly improving, and certainly the tribunal system is doing its best to deal with things. But the problem is cases are being listed in 27, 28. Where's the deterrent there? because an employer might think, well, I'm not going to bother settling that because I've got 3 years to worry about it.
Mhm.
And I might not be, you know, the chief exec or the HR director may say, well, I'm not going to be here in 3 years, so I'm not fussed. You know, it kind of becomes that situation where it can go on the back burner. So what I certainly, my experience tells me, having a more efficient system that deals with cases quickly also leads to settlements more quickly, because there's a real deterrent effect. So, but the answering the specific question, I'll get off my, my soapbox, but the ERB doesn't make any mention of additional resources, but there needs to be, because the extension of the time limit probably will help. So 3 months to 6 months, probably allow more time for cases to settle and not be issued. But it's not going to make a significant impact, I would have thought, and it does need more resources to have a fully functioning system.
Mm.
But I guess I'm afraid that's it applies to a lot of things at the moment. So we will have to continue to do our best and work with the system as it is. They certainly, you know, sorry to go, I mean, in terms of ACAS, I think they do a fantastic job, and the ET service, but they need more people and they need more resources.
Yeah. Okay, that's all the questions. Thanks very much.
My pleasure.
Does anybody have any more questions? Anybody want to ask a question direct to David? Don't know if we can take you off mute, Brian, but we'll give it a go. We got you off mute. Let's go.
There we go.
There we are.
There's a lot of people would prefer to keep me on mute. Hiya, David.
No comment.
Hi, Brian.
Thanks for that. I really appreciate it. It was really, I think there's a lot of exciting stuff in there, you know, and when this comes through to fruition, it's going to make a lot of positives for unions. And I look forward to working with unions for the second bill, which I'm sure we can talk about at a future date. I just want to focus on the trade union access, or the right to roam, as some commentators call it. There's two aspects to this. One is employers seem to have a bit of ambiguity around it. I've already had comments from one employer who said at the beginning of a pay negotiation, you know, if you make life difficult for us, we can let another union walk into the through the door under the new bill, which I think is incorrect. This is more focusing on unrecognised workplaces. I think the big concern that we have with other unions is, will it start the opportunity for bigger unions to come into recognised workplaces where smaller unions have recognition? And if that is the case, do you think there's a responsibility on organisations like the TUC to put in some rules for all affiliates to ensure that doesn't occur?
No, I think it's a very good point, Brian, and I think I agree with you. The thrust of what you're saying, we need to be careful here. There's certainly it does. It builds in a mention of existing unions and sort of, I think there is an intention that they are not going to be kind of pushed aside, if I put it in that way. So that is in there. But again, it's the feedback needed as part of the consultation, isn't it? And the information coming through to make sure that happens, because it needs to be a fair playing field. And I certainly think in terms of the sort of wider union movement, an agreement really here to work sensibly together is the benefit of all, isn't it? And because this is a great opportunity for unions to have a good voice across more workplaces, and certainly those where unions have potentially, certainly over the last few decades, been less visible in some of those workplaces as well. So I think it's a great opportunity, a very positive one. And again, I know the current government have had a lot of criticism, but when I look at the announcements they've made, that there is a consensus that this is a good thing and that it is intended to allow sensible improvements, unions to be involved. And there's a lot of mention of union involvement throughout the process, even in some of the aspects that are not particularly necessarily directly impacting on unions and union members. So there's certainly there's good messaging. Well, there's clearly, I say good messaging. There's good thoughts there, and it's there, but unfortunately, it just seems that communication isn't getting out there as widely. And I do think the government's communications on this and on the benefits of the Employment Rights Bill really could be significantly improved, because it's almost being turned into a bit of a negative now as a kind of unions charter type thing, which it isn't. It's a, you know, it is, the intention clearly within it is unions working together with employers, but having more rights and a more acknowledgement of union rights and the importance of unions in the workplace. So, and also, you know, link it into that growth piece in terms of that being a positive thing, and unions and members and workers contributing enormously to the economy. So it has that sort of sensible messaging, but it's just not getting out as much as we'd like.
Thanks, David.
There's another question coming from Steve Grotte, who apologises his camera's not working. Great session. If these changes come into effect, how long are they likely to be enshrined in law? Thinking of the potential landscape in the future and parties less in favour of unions.
Oh, yes, Steve, that's a tremendous question. It's beyond my skills, really. It's very much a political ride, isn't it? In terms of what happens further down the line. Certainly, the employment law, I mean, it makes you realise what a political hot potato employment law is, and always has been. Looking a little bit, the anniversary of the Race Relations Act is coming around in a few weeks. And looking back over the history of that and the contention over that now seems, I think most right-minded people would think, well, of course, that was something we needed back in 1965. But actually, at the time, there was quite a lot of opposition. And again, here, a lot of these changes are being quite heavily opposed, I think, by Reform, of course, in the House of Lords, by Conservative peers and Liberal Democrat peers, I understand it. So there's quite a lot of opposition there. How long they last? Well, I think a lot of them would bed in for a good amount of time. And certainly the positive aspect of employment law is even those areas which were often opposed at the time by certain political parties or individuals often have stood the test of time. So that and social change comes about because of it. And I'm pleased to see that in my working time, age discrimination was seen at the time as quite that could be quite difficult. That could have these impacts. Religious protections against religion and belief were seen by certain quarters as being, that really could have terribly implications. But actually, they've come in, and most people again accept it. So to go back and change that, you would hope that would never happen. We'll have to wait and see. But I do think a lot of these changes, if they come through, will be popular with a lot of workers, a lot of people, and hopefully will be here to last. But yes, fingers crossed.
Thanks very much.
Looks like we've got somebody else that wants to ask a question direct as well, David. So Stephen Conway, get you off mute. We get you off mute, Stephen.
Your mic's enabled, Stephen, if you just want to unmute yourself.
Thanks, Chris. Stephen, do you want to come in? Maybe not. Oh, his microphone's not working. Do you want to type your question in the chat? No, it doesn't look like it. So if we get that question in, David, are you okay if we send that question on and then we can send the answer back to Stephen that
Absolutely.
way? Yeah. Thank you very much, David. That was a really excellent session. Lots to go through, lots of information. There's been a question, are we going to share the slides afterwards? Yes, we will do. So Fiona, do you usually send it out to everybody that's attended, or do you want requests to come in?
I've just asked Chris if he can give me the emails of everyone who's attended, and if you forward the slides on, I'll send them round.
Perfect. I'll do that straight away after this session. And as always, within the next day or so, the recording of the session will be on the Alliance for Finance website as well. So if anybody has not been able to attend and has missed it, it will be available to watch back in your own time as well. It usually takes just a day or so for us to get that uploaded. So thank you very much, everybody, for attending today. We will be in touch shortly towards the back end of the year to let you know what seminars we're looking at putting on for 2026. So we look forward to seeing you at some of those seminars next year as well. And once again, David, thank you very much for the updates. Very much appreciated.
My pleasure. Thanks for having me.
Thank you, everybody. Bye-bye.
Bye.